A very good morning to you all, friends. I am Sanjeev Singhal, Central Council member and Chairman of the Auditing and Assurance Standard Board and Chairman Sustainability Reporting Standard Board. I welcome you all to this very important webinar on this Friday morning on SQC1 and SA220. SQC1, friends, it's a statement on the quality control. It talks about quality control for firms which perform audit and reviews of historical financial information and other assurance and related service engagements. So as the name implies, this standard talks about what are the quality processes available within a firm and which firm? Those firms which do audits and which also review the historical information, and audit is always of the historical information, and any other assurance and the related service engagements. The second topic is related topic, SA220, quality control for an audit of financial statements. So, friends, we have seen that quality, and quality. We are hearing a lot about the emphasis on quality, audit quality. Whether you look from the tone at the top from the government or the President ICI, who talks about audit is a serious business, or you hear any other regulator, everyone talks about quality. And as chartered accountants, we are competent to do our job with quality. But these two standards will talk about what is documented, how we document the quality processes, the internal processes, and also the fact that if it's a listed entity engagement, there needs to be an EQR, an engagement quality reviewer. There has to be an independent partner who is reviewing those work papers. Question may also arise that how it will happen when it's a sole proprietorship firm, because a sole proprietor can also do an audit of a listed company. Then what should be the guidance which should be available? Well, it is not necessary that an EQR has to be from within the same firm. If within the same firm an EQR is not available, person can be taken from outside as well. We at the Auditing Standard Board are also working in this direction of issuing more guidance on the compliance with this SQC1, particularly from the perspective of small and mid-sized firms. But friends, there is no alternative to quality. And auditing standards are very, very important. That is why in the 24th Council, in which our keynote speaker, Satish Gupta ji, the then Honorable Central Council member, was also a part, made 2 CPE hours mandatory on auditing standards, apart from Code of Ethics. And it's a conscious decision of the Auditing Standard Board this year to organize awareness workshop on all the auditing standards. We started this series in the first week of April. And now, after today's webinar, we are left with only 2 more auditing standards. We'll be covering all. We are organizing physical as well as the virtual programs. And this is the 33rd program on auditing standards by the Auditing Standard Board in this council year. And friends, there's been overwhelming response. In every such webinar, about 3,000 people participate. And we have got the best of speakers because our members always, they are willing to contribute to the cause of the profession. And friends, this year, we have also, in order to enhance audit quality, in order to support our members, particularly those, who may not have much of a technical guidance available in-house, a very big step has been taken. Every year, we used to constitute a panel for online panel for experts to answer queries on bank audits. But this year, apart from bank audit panel, we also constituted an online panel of experts to answer queries relating to statutory audits of companies, of partnership firms, and of the proprietorship firm, etc. Companies itself, we have 14 lakh companies. And even if I assume 6 lakh partnership firms and sole proprietorship, so it's much more. So we will be catering to the audit-related queries of our members, which they face during these audits. And this panel is already live from 16th of April, and this will go on till 30th of September. And our endeavor will be to answer the queries within a day or two We have already empaneled 50 experts for the same. And if you also want to be an expert, if you can devote 3 hours in a week for at least 10 weeks during this period, please feel free to write to us along with your profile. Friends, it's the endeavor of the Institute, and quality comes first. And that is why these initiatives have been taken. We are also working expectation gap, which is very, very important because the society and the government expectations and the role of the auditor match somewhere. And friends, today's topic on quality control will be spearheaded by two of our renowned speakers, and CA Hasmukh B. Dediaji. We are very thankful to both these speakers for giving their precious time on this Friday morning during this busy audit season. But it's indeed a pleasure to have my honorable council member of the 24th Council, CA Satish Gupta ji from Jaipur. During his last term, he was also the chairman of the Committee for Member in Practice and came out with various publications concerning the members in practice, came out with various schemes for softwares and other discount schemes on which I capitalized and improved it further during my term as chairman for Committee for Member in Practice. Satish Bhai comes from a background where he understands the pain of the small and mid-sized practitioners and the challenges which they face. Satish Bhai made enormous contribution to the council and was a very valuable asset to the council. I'm thankful to you, Satish Bhai, that you have taken out time and agreed to be a keynote speaker. And I would request you to kindly enlighten our members with your keynote address. Thank you, and over to you, Satish Bhai.
Thank you, Sanjeev Bhai. Thanks a lot. CA Sanjeev Singhal ji, Honorable Chairman of the AASB of the ICAI, CA Vishal Doshi ji, Vice Chairman, Honorable Speakers of the day, very learned CA Sri Sandeep Sharma ji, CA Hasmukh B. Dediya ji. I have heard a lot about both of these speakers, but I want to tell you first that CA Sanjeev Singhal ji is a wonderful person and a very dedicated council member. I have seen him working for the benefit of profession, for the benefit of members at large. And friends, what I felt during my council period, that Sanjeev Singhal ji had a very big pain for the small and medium firms also. As I saw his dedication to bring the audit tools for the benefit of our members. And I hope that this year we will be having those tools for the benefit of members. So Sanjeev Singhal is very dedicated chartered accountant, very dedicated professional, and working in council a lot. You see, friend, that 33 programs on audit standards. I think it is first time from last several years I am seeing this much of dedication, and just to propagate all the standards for the benefit of our members. But I would request Sanjeev Bhai that we must take that you talked about the expectation gap, and that is a very big gap, because whenever some challenge comes to the profession, the stakeholders' expectations is so much from our profession, and all the responsibilities come on the shoulders of the profession. So we should try to hold as much as meetings for the public at large also, to explain them what is the audit, what is the financial audit, what is the difference in between forensic and the financial audit, and what can be expected from a chartered accountant doing the audit work. So friends, I am just thankful to Sanjeev Bhai and AASB for giving me this opportunity to be before you all and share some of the views. If we talk about that, what are the three words which are the most suitable to the audit, friends, the three words I would like to tell: quality, quality, quality. Because quality includes everything. Quality includes documentation, quality includes ethics, quality includes standards, quality includes the role of stakeholders. In quality, we will find each and everything. So if we chartered accountants will follow our standards, I think we can ensure the stakeholders about the reasonable quality of the financial statements after our audit. Yes, there are big challenges in the changing scenario, and as Sanjeev Bhai has rightly explained that under this time, we will have to be very much cautious while performing the audit work, because independence, I know integrity, independence, documentation, engagement performance, monitoring, all are the part of the SQC1. And I have seen that Sanjeev Bhai, whenever there was a council meeting discussing the audit standards, he has always emphasized on the SQC1, importance of SQC1. And this is because we are seeing that a lot of work is being done on the SQC1. And friends, see, nowadays, when peer review is there, nowadays where UDN is there, so our responsibility has become big, because UDN means it is not your private document now. Now the things have come to the knowledge of all the stakeholders, to the government. They can see your audited statement anytime. So we must take care while doing our audit. And friends, I would request Sanjeev Bhai that in AASB, apart from standards, we should see that how can we enhance the skills and competence of our chartered accountant members. Because simply knowing the standards, I think will do the 50% of work, and balance 50% will come out of competence, out of knowledge gaining, knowledge enhancement, and how can we perform the audit work. I am really thankful to you and your AASP for making a group to help the chartered accountants in doing their audit, not only bank audit, but also in the corporate audit also. So it is really a wonderful thing which will go a long way in the times to come. SQC1 and SA220 seems to be same, but friends, there is a difference. Although both of these standards are related to quality, but SQC1 talks about the quality of the firms, and SA220 talks about the quality of the financial statements. So we must take care of in giving although both of the speakers will talk about both these SQC1 and SA220, and they will also talk about the difference between two. But I would like to say that audit is our bread, not only bread butter, but it is our goodwill, it is our reputation, and we should take care while performing the audit that how we perform the audit, so our reputation and our goodwill is not at the stake. So thank you very much, Sanjeev Bhai. Thank you very much. Thanks a lot for giving this opportunity to share my views with all the audience available today. Thanks a lot. Really obliged.
Thank you, Satish Bhai. Thanks a lot for your keynote address. Anilji would request you to kindly take the session forward. Sandeep, will you be speaking first, or Asmukji, you will be speaking first?
Sir, Sandeep sir will speak first, sir.
Right. So would request Sandeep Sharma-ji, who's also our special invitee of the Auditing and Assurance Standard Board, to kindly start this.
Sure. Thanks, Chairman, sir. I will share my screen with the presentation, and we will discuss around the presentation. What are the contents of SQC1 and what are the members supposed to do? Is my screen visible with the presentation?
Yes, sir. Yes, sir.
Yes.
Okay, thank you. So, friends, we will start with SQC1. As Chairman sir has stated, and Mr. Satish Gupta has also deliberated on it. This standards relates to the quality control system for firms that performs audit and other engagements. So in a way, SQC1 is different from other standards, which are more of engagement standards. It can be standards on auditing, standards on review engagement, standard on related services, and standard on assurance engagement. This standard is not on the engagement, but about the firm as a whole. What is the kind of quality control system the firm should have in order to be in the position to perform the engagements? We will start with the introduction, the definition which are inbuilt in the standard, the 6 elements of SQC1, and then finish with the documentation requirements. In terms of introduction, the purpose of standard is about the firm's responsibilities for SQC to establish standards and provide guidance and on the policies and practices regarding two things. One is audit and review of historical financial information, and second is other engagement, which are assurance and related service engagements. Friends, it applies to all the firms, whether the firms doing listed companies audit or doing audit of unlisted companies or performing review engagements or certificate engagements. Why SQC1 is important and why we should talk more about system of quality control is that we know in a CA firm the biggest asset are the people, and in order to to do high quality work, we need processes and systems in place. These processes should be documented and should work consistent. For firms to have consistent methodology in terms of the work that they are doing and in terms of outcome that they are achieving. The objective is SQC should be designed to provide assurances that the firm and its personnel comply with professional standards, and professional standard can be as per ICI, Code of Ethics, regulatory requirements or legal requirements, and also to assure that the reports issued by the firm or the engagement partner of the firm are appropriate in the circumstances as per the scope. So in a way, SQC comprises two things. First of all, the policies which are designed to achieve objectives of the standards, and secondly, procedures which are necessary to implement and monitor compliance with these policies. Because designing the policies is not sufficient. We need to have processes in place to ensure that the policies are working consistently throughout the engagement cycle and throughout the engagement of the firm. The nature of policy and procedures depend on for each firm may depend on the size of the firm or operating characteristics of the firm, whether it is working in isolation, whether it is a part of a network. It also depends whether the firm is in reality sole proprietorship or a firm with 5 or 6 partners or more. Because each of these elements will change the way the firm operates the policies, the firm monitors the policies. SQC should be read in conjunction with the code as SQC1 defined. The code includes requirements of CA Act 1949, Code of Ethics by ICI, and other relevant pronouncement of ICI. There are other standards of guidance which also provide reference to what we should be doing in terms of quality control system. Example, SA 220. When we come to definitions, these are the definitions which are given in SQC1, and these definitions are important not only for reading SQC1 but also to go through the other standards as well. Engagement documentation is essentially a record of what is the work that has been performed, what are the results of the work that has been done, and what are the conclusions reached because of the work that has been performed and the result that have been obtained. We say many times that if the work is not documented, this is not done. It is because if we do the documentation right, then any third party who is coming for the review or inspection and looking at the work papers will be seeing the work done in line with the work that has actually been done. If the documentation is not right, then someone might say this has not been done because there is not evidence. Such work is assembled for each engagement separately in the engagement file, which is maintained by the firm. Now, who is engagement partner? Engagement partner is a partner in the firm. For doing audits or reviews, it is essential that the person should be a member of ICI, should be in full-time practice. The engagement partner is responsible for the engagement and its performance and outcome. Thus, he is also responsible for the reports issued for that engagement. EP has appropriate authority from the professional or regulatory body to do so. Engagement quality control review process. This is a process which is designed to provide objective evaluation of the engagement before a report is issued, because there's no purpose in having this review after the report is issued. And the main responsibility is for significant judgment and conclusion engagement team, because engagement quality control reviewer is not part of the engagement team, but is a person who is outside the engagement team. That person can be in the firm, or if we are talking about a sole proprietorship firm, that person can also be a suitably qualified person outside the firm also. EQCR is a person with sufficient appropriate experience and authority to objectively evaluate significant judgment which have been taken in the engagement team, to ensure that the decisions have been taken consistently in accordance with the professional standards, in accordance with the policies of the firm, and these are not designed to compromise an audit engagement. Engagement team is led by the engagement partner and includes all the personnel who are performing the engagement. As I said, EQCR is not a member of engagement team. Engagement team not only include the core people who are doing the audit, but also include the experts who are part of the engagement to audit support. It can be experts within the firm, it can be experts outside the firm, but it does not include the client's internal audit function people who provide direct assistance on audit engagement, which is in line with SA 610. Then we come to who is a firm. Firm can be sole practitioner, firm can be a partnership, or any other such entity of professional accountants permitted by law as per rules and regulations of ICAI. Inspection can be for complete engagement, and procedures are applied on engagement team, and it includes evidence of compliance with firm's QC. Listed entity is any entity whose stocks, shares, debt, or other securities are quoted on a recognized stock exchange. Monitoring. Monitoring is a process which considers and evaluates the firm QC system, which may include periodic inspection of selected and completed engagements. The idea is, we have the policies in place, we have processes in place. Now the firm wants to have reasonable assurance about whether the system which is designed is also operating effectively. So monitoring is the process which gives such assurance. Network is a large structure which complies with the network guidelines of ICAI, and network firm is a firm or entity that belongs to a network. Partner is any individual of the firm who has signed the partnership deed and who has authority to bind the firm with respect to performance of professional service engagement which are performed as in line with the professional standards laid down by ICAI. And personnel can include partners or employees of the firm. Reasonable assurance is, we talk about reasonable and limited assurance many times. Reasonable assurance is a high level of assurance, but not absolute level of assurance, which is not designed to be there. Suitably qualified external person is being discussed many times in SQC1 and other standards. It is basically an individual who is from outside the firm, who otherwise has the capability, experience, and competence to act as an engagement partner if the person was to be in the firm. And the suitably qualified external person is used more in those cases where the firm has only one partner, or essentially sole proprietorship. For example, EQCR, and for doing inspection and to give to monitor the processes. Now we come to elements of system of quality control. There are 6 elements, and the most important ingredient for the system of quality control is documented policies and procedures. So the logical question is, what areas a firm should have policies and procedures? SQC provide the answer to this question. It starts with leadership responsibilities for quality, which is essential and which sets the tone at the top. It starts with the vision of the firm, and all the policies start from the way the managing partner or CEO of the firm thinks the firm should perform. Then we come to ethical requirements, which are those requirements for otherwise for a profession cannot exist if these requirements do not exist. Then we come to acceptance and continuance of client relationships and specific engagements. Before you start a relationship with your client or take on an engagement with the client, you need to assess whether you want to accept those clients, whether you want to accept those engagements, and if you accept it, whether you want to continue year after year. So there are specific matters that need to be looked into, which we'll discuss in detail in the later slides. Human resources, the biggest asset of the firm. Right from recruitment to the entire life cycle, we need to have monitoring aspect. We need to have the right quality of people. We need to have sufficient quantity of the people who should be continuously trained and motivated to do the work so that any engagement is performed as per expectation of the professional standards. Engagement performance is the actual work that we do in terms of audit or in terms of review, and these are the minimum arrangement that a firm should make for delivery of the engagement. With all these five elements of system of quality control in place, we come to monitoring, which is there to ensure everything is working the way it was designed. So in nutshell, SQC must include policy and procedures which addresses each of these 6 elements. And these policy and procedures should be documented and communicated to the firm's personnel. And why is that so? Because policy and procedures are made fine. Now the quest is how to achieve compliance with these policies. There should be clear communication to the people. So in order to achieve compliance with policy and procedures, it is a must that these policy and procedures are communicated to personnel. The objectives which are to be achieved by SQC should be communicated to the people, and all firms personnel should be responsible for quality of the engagement, quality of the system of quality control, and each person is expected to comply with these requirements. The firm is encouraged to provide a system of feedback so that people provide feedback on the quality of SQC. Now, there is a saying that people follow shadow created by the leader. That is very much relevant in the first element of the SQC that we are discussing. It is the responsibility of the CEO or managing partner or equivalent a person to assume ultimate responsibility for the firm's SQC. For the members who have gone through peer review process, it requires the definition of who is the one who takes ultimate responsibility, and typically we say it is the CEO or managing partner or such a person. Because it starts from the CEO. Firm should establish clear policy and procedures which are designed to promote an internal culture which is based on recognition that quality is essential in performing engagements. Now, who should be responsible for the operational responsibility of the firm's quality? The person who has sufficient and appropriate experience and ability, i.e., the person who understands the issues, who develops the policy and procedures, and who has the ability also to take necessary authority. Authority is to enable implementation of policies. So if we have a person who has experience but does not have authority, that person may not be assigned the operational responsibility. Now it's a responsibility of leadership to promote a quality-oriented internal culture. So leaders lead by example, whether in terms of ethical principles or technical knowledge. So people follow the leaders. There should be clear, concise, consistent, and frequent action and messages to the people. So CEO, for example, may speak to people in meeting, may write emails, or give other kind of messages to the people, so that the work that is imbibed in the professional standards are done as per satisfaction. It is essential not just reward people who bring in business, but also people who perform high quality of work consistently. So it is a responsibility of the leader that business strategy is subject to quality. So it is very essential that leadership ensures that the commercial consideration do not override quality. There are sufficient resources who are devoted to quality function, and the leader ensures that the policies and procedures are devised in such a way that it balances the performance evaluation, compensation, promotion based on quality criteria. We come to next, which is ethical requirements. There are 5 fundamental principles of professional ethics: integrity, objectivity, professional competence, and due care, confidentiality, and professional behavior. Each of these principle is a vast topic, and we should uh, integrate these principles in our values that we go with day to day work. Now we have talked about ethics are driven by values and belief that get made from the experiences that people get. How does a firm create these values and experiences? By leadership messaging on ethics, by having appropriate education and training plans on ethics, by designing the process which deal with non-compliances, including disciplinary action taken against a specific partner or employee in case specific situation, and by having appropriate monitoring process on the entire function so that these things can be tracked and evaluated accordingly. Let us not forget who needs to comply with this element of SQC: the firm, its personnel, all the firms in the network, people in the network firms, and other people, for example, experts who are contracted to do specific engagement. Everyone needs to comply with ethics, independence, and these policies. And you need to ensure with the compliance with the code when required, fundamental principles, and also part 4A and part 4B of Code of Ethics. Then we come to what is the purpose of independent policy procedures. It is presumed that the system should provide reasonable assurance that everyone who need to comply, which is the firm, its employees, and other people, will maintain independence. In case there is a breach, the system should be designed in such a way that the firm is notified breaches of independence requirements. How do we do that? These policies and procedures must enable the firm to communicate its independence requirements to everyone in the organization, identify and evaluate the circumstances and relationship that create threats to independence by way of manual. These things can be detailed so that people know what they are supposed to do. In case there is requirement of any action, then take that appropriate action to eliminate those threats or reduce them to an acceptable level by applying safeguards. If everything fails, then the firm may consider it's appropriate to withdraw from the engagement. Now, these policies and procedures should require the engagement partner must provide relevant information to the firm. This helps to evaluate overall impact on independence requirements. This information could relate to relationships and the scope of engagement. Secondly, all personnel responsible to highlight circumstances and relationships that may create any threat enable the firm to take appropriate action. Lastly, and most important, accumulation and communication of information of relevant information to appropriate people should be there. Now, how do we do that? The firm and personnel should readily determine the compliances. The records are maintained and updated relating to independence, and so that if there is a need to take any appropriate action, it can be done to eliminate any threats to independence. The firm may have a list of entities where the partners are directors or have business interests, so not to pursue any engagement in those entities. The firm may have a list of engagements which are PI or banking NBFC clients where people are not supposed to be indebted beyond a certain limit. People should not have investment in these entities. So the firm should maintain appropriate records. Now we come to breaches. The system should be designed in such a way that the there is reasonable assurance that the firm will be notified. And SQC is a process which enables the firm to take appropriate actions. In case of any notification of breach, it should be prompt by the firm's personnel. Firm, in case of any breach, what the firm should do? It can communicate, or it should communicate to the engaging partner and others within the firm designated to take actions. It can be CEO, it can be a dedicated partner who is responsible for taking action in such scenarios. And it is also essential that the engagement partner should communicate action taken to the firm and others within the firm. For example, there is a breach, engagement partner has taken safeguards and action. So after the breach has been notified, the EP should communicate on the follow-up action that has been taken. So which will result in the firm to determine whether there is any further action which is required. The firm may decide that the appropriate action will be taken and we can continue with the engagement. The firm may decide that even if the action has been taken, but these are not sufficient. So whether it is appropriate to withdraw from the engagement because independence and objectivity cannot be maintained. Then there's a requirement in SQC1 that there should be independence confirmation from everyone in the organization to whom independence policy apply on an annual basis. This should be in written, can be in paper form, can be electronic form as per the databases of the firm. If this indicates any non-compliance, it should demonstrate the importance of independence to all its personnel. Now, what are the factors to consider in setting criteria? Whether any public interest is involved in any entity. It is not only the people who are in the firm, but also the personnel who are leaving the firm should also confirm till the time they are in the firm. Is there any indicate non-compliance? Follow-up action should be taken by the firm to have safeguards, basically to provide. It may have penal actions, for example, demotion or monetary fines. In extreme cases, the firm may also require the person to exit the firm. Third element is very important: acceptance and continuous client relationship and specific engagements. Can anyone who approaches your firm will become your client? Or would you as a firm will take on any type of engagement that comes? Maybe not. And the reason is we obviously go through the background of any client to see whether there is a client integrity. So what we do background checks of the client, of the shareholders, promoters, and of the directors and key managerial personnel. We communicate with previous auditor. We follow ICI guidelines on KYC of the clients to ensure the client integrity is there. In terms of engagement requirements, we assess whether we as a firm and its people have experience in providing services which have been asked for, whether we have sufficient resources in terms of people to perform those engagements, whether we have time to perform those engagements. So these are the questions that we normally ask ourselves before we accept any client or specific engagement. If you provide these services, will you be able to comply with ethical requirements? You need to gather all these relevant information and document before you decide whether you want to undertake a new relationship or new engagement. Only when you get proper assurance by doing all this work, you should accept a client. In terms of integrity consideration, we see the reputation of a business, we see the reputation of the promoters. If, for example, if we find any promoter, we can do Google search, we can speak to few people in the firm who are associated with that client. If we find out that any promoter has been involved in a negative news recently or in the past, for example, non-payment of loans, we should stay away from these entities. We should be fully be conversant with the nature of client's operation, including business practices. And the firm may have different criteria for accepting new clients. For example, they may have certain industry sector where they want to perform or not want to perform. Any firm who, for example, I'm just taking an example, any firm who does not have any person who has done audit of a bank may not accept any banking client as a audit client. So if there is indication that there will be inappropriate limitation in scope of work, management may not give information to us on timely basis, client may be involved in money laundering or criminal activities, we do not accept these audits. We also consider firm's capabilities, which is internal, whether we have appropriate industry subject matter knowledge among personnel, whether we have availability of experts which are required to perform these kind of engagements, whether we have ability to complete engagement within reporting deadline. If we are accepting a client, let's say in first week of April for March year end, and if client says you have to complete the audit by April end, and we do not have sufficient people, we should not accept these audits. And we also need to think of ethical issues before we complete our assessment of acceptance or continuance of engagements. In the extreme situation, we may decide to withdraw from the engagement. So before we do, we discuss with appropriate level of clients management and those charged with governance, the board of directors, audit committee, as the case may be, regarding appropriate action that the firm might take based on facts and circumstances. And this can be if there is a limitation by management on the work that we are doing, if we don't get information in time, or there's an incident that has been notified to us based on whistleblower incident or a fraud, which is resulting in our not completing the engagement. As a firm, we need to determine the reason for withdrawal, and there are requirements for the firm to consider. For example, we need to see auditing standards which are giving what are the possible reasons in which we can withdraw from the engagement, and these also have been documented in implementation guide by AASB on resignation of an auditor. We need to document all the significant issues, consultation that we have done within the firm, the conclusions that we have derived, whether we want to withdraw or not to withdraw, and the basis of such conclusions. In the end, we also document our reasons and action plan with the management in writing. Human resources, as we said, this is the biggest asset that we have in the firm. We should have sufficient number of people, capable, competent, and people who are commitment to ethical principles. So all policy and procedures in human resources should address the entire life cycle, starting from recruitment of these people, and then going on to performance evaluation, assessing their capabilities, assessing their competence, taking care of their career development, promotion where commercially viable and where people are found suitable for next level, give appropriate compensation for them to continue in the engagement, uh, basically assessing the overall workload and work plan, and provide training. After recruitment, we also need to see assignment of engagement team, whether engaging partner or the staff. This is done in line with what is the competence of partner or the staff for that audit, what are the time available with a specific person, what is the manpower plan of the firm, and what is the timing required for the audit by the audit client. So we need to consider everything before we decide on assignment or engagement team. For example, we might a particular person to be suitable for a specific audit, but if the person is already been assigned to different engagement, the firm should take a decision whether the person should be on the pre-assigned engagement or should work on a new engagement. Engagement performance is what we know as the real work in terms of engagement, whether audit or review. Essentially, the policies should be designed to provide reasonable assurance that the engagement which are performed by the firm are compliant with the professional standards, are compliant with the laws and regulations. In the end, we need to be sure that the reports issued by the firm through engagement partner are appropriate in the circumstance are as per the scope of work which is required by the law and regulation, are as per the scope of work which is agreed with the client. Basically, the policy and procedure should be if these are documented, should bring consistency in engagement performance. The methodology, if it is documented across the engagements, the same methodology will work in all the audit engagements. It can be in written, it can be in electronic manual, it can be in software tools or other forms of standardized documents. Can be industry specific or general guidance material. For a bank, the firm may have a different methodology from a manufacturing company. It is essential that we brief the team. All members should understand objectives of the work allotted to them. Teamwork and training is necessary to assist less experienced members, because the people, for example, interns, people these are given on the job training by their managers, by their supervisors, so that they do the work, become experienced, and move up to the ladder, and they train further people who are coming into the profession. We should consider the capabilities, competence of individuals on the team, whether they have sufficient time, whether they understand instructions, whether work being carried out by planned approach to the engagement. If there are any issues arising during the engagement, whether technical or non-technical, we should consider their significance and appropriately modify the planned approach. Now, from time to time, there is a need for any consultation in the engagement performance. So the system of consultation promotes quality and improves application of professional judgment. It includes discussion at appropriate level with experts, whether inside or outside the firm, depending on the size of the firm. It is established and is encouraged to have culture of consultation. We may have various topics, for example, contentious matters or technical matters are there. So what we do have appropriate consultation. We document what was the nature and scope of consultation and what is the conclusion, and keep these as part of audit work papers. Now, if there are different opinions, what do we do? There can be difference of opinion within engagement team. In that case, engagement partner takes a decision. We may have difference of opinion with those consulted, or between the engagement partner and EQCR. In that case, we go to appropriate person who is designated to take a decision, and that person can be quality control leader or the assurance leader, as the case may be. In all these cases, we should document what is the difference of opinion and what was the conclusion and the basis of that conclusion. It is mandated that till the time the matter is resolved, report must not be issued by the firm. We come to EQCR, and that's a very important function. Each firm should have policy to have EQCR in certain engagement. Listed entities is mandatory. The firm may require other entities to have EQCR also, maybe on engagement which are going through going concern issue, maybe engagement whose financial statements are widely circulated, maybe on engagement which are not yet listed but going through IPO process. So any firm may have its policy to have EQCR, and where it is mandates involvement of EQCR, it should ensure that EQCR should be there. Now, it is required that the engagement partner should not have any say in appointment or nomination of EQCR to maintain objectivity. The system should also list down the nature, timing, and extent of review by EQCR. It also lays down the criteria for eligibility. It may be qualification, experience, authority, location, and also requires a degree of consultation with EQCR. So all EQCR review is documented. EQCR review is completed before report is issued, and there should not be any unresolved matters before the report is issued. Engagement documentation is very, very important. First is completion of assembly of final engagement file, which can be in line with SA 230. These are the procedures that the firm adopt for retention of engagement documentation, including those that enable the retrieval of and access to the engagement documentation during the retention period, particularly in case of electronic documentation, since the underlying technology may be upgraded or changed over time. As per SQC1, the minimum period for which engagement work paper should be retained with the firm is 7 years. The firm may choose a different policy. It may decide that we will retain engagement work papers for 8 years or 9 years, whatever that period might be. One, that period should be consistently followed by the firm. Second, that period should not be less than 7 years. And then there should be a process of purging the documents beyond the retention period decided by the firm. All these documents should be in the safe custody and should be retrievable. Last element, and I would say the most important element of SQC1 is the monitoring. We may have policy and procedures in place to ensure compliance with other 5 elements. But if there is no monitoring, then there is no assurance of the QC system that those policies are working in the way they are designed to working. So we need to have assurance that the policies are relevant, policies are adequate, policies are operating effectively and complied with in practice. We may test the various policies and procedures. It may involve periodic inspection of completed assignments as well. There should be a responsibility of monitoring on the partner or specific individuals within the firm with appropriate experience. Purpose is we should evaluate whether professional standards were adhered or not, whether the QC system is designed and effectively implemented, and whether QC has led to reports appropriate to the circumstances. In terms of monitoring, responsibilities assigned to partners who are competent, who have appropriate experience, and who have authority. Small firms and sole practitioners may wish to use a suitably qualified external person or other firm to carry out engagement inspections and other monitoring procedures. Alternatively, they may wish to establish arrangements to share resources with other appropriate organizations to facilitate monitoring activities. This is also something which has been written for AQMM by CAQ. In terms of monitoring, there may be engagement findings which are discussed with the engagement partners and other relevant individuals within the firm who are basically CEO or the quality control leader of the firm. If the deficiencies are noted which are not significant, we can close at that. If deficiencies are noted which are significant, then we have to evaluate whether these are systemic issues within the firm, whether these are repetitive findings. We need to have prompt corrective actions which can range from correction in the individual engagement or sharing findings with L&D team of the firm, which can run training programs on that deficiencies so that these deficiencies are not repeated in other engagements of the firm. If required, the firm should change its policies and procedures to plug the gap if there is any deficiency in the policies per se. In the extreme case, there may be a disciplinary action which can be if the firm finds that these deficiencies are a result of deliberate or repeated actions by the engagement partner or engagement teams. It is important that the results of monitoring are communicated to the respective engagement partner, to the CEO, and other appropriate individuals within the firm. And these results should be communicated, in addition to communication, should be documented. What are the procedures performed for the monitoring? What are the conclusions which are drawn? And if there are any action taken, what are those actions taken to resolve or amend deficiencies? So ongoing evaluation of QC system includes analysis of new developments, continuing professional development, including training, determination of corrective action, communication of weakness identified to appropriate personnel within the firm that we have discussed. This is a very important topic. From time to time, there may be complaints or allegation by people within the firm or people outside the firm. So the firm should establish policies and procedures which deals with these complaints and allegations that the work performed by the firm or specific team or individual fails to comply with professional standards. There may be allegations of non-compliance with the firm's SQC. It is the responsibility of the firm to investigate such complaints and allegations unless these complaints and allegations are clearly frivolous. These should be supervised by a dedicated partner who has sufficient and appropriate experience and authority, and who is not otherwise involved in the engagement. And where necessary, you should also take help of the legal counsel of the firm or maybe external lawyer. Small firms and sole practitioners may use services of a suitably qualified external person or the other firm to carry out the investigation. These complaints and the responses to them should be documented. Documentation. So when we have engagement documentation, then we have documentation around the SQC. Large firms may use electronic databases. Small firms may use more simpler informal methods such as manual notes, etc. How matters are documented is firm's decision. One of the factors is size of the firm, number of offices, number of partners, degree of authority both person and officers have, and nature and complexity. It is essential that the firm retains this documentation for a period of time sufficient to permit those performing monitoring process of a longer period if required by law or regulation. Now, coming to SQC, why this is important? This is also important because we understand peer review process. SQC1 is discussed and inspected during NAFRA or QRB inspection. These are inspected, and even in case of regulators outside India, for example, PCOB in US or FRC in UK, they also go through firms SQC policies and whether the system is working as designed or not. We can also take a minute to discuss the key findings by QRB in 2021. This is a report released by QRB for FY 2021. So it says number of audit firms covered having findings in SQC1 is almost 36-37% in each of the year 18, 19, and 2021. So this is almost every third firm has finding resulting from SQC1. The key findings are failure to implement various elements of system of quality control or EQCR, lack of awareness in maintaining staff appraisal policy, failure to maintain policy and procedure to notify the firm of breaches of independence requirement. So some of these might be presumed to be inconsequential, but each of these elements is very, very important for the firm to be seen and acting as a mature and responsible firm. What are the key takeaways? You should implement and document the various elements and keep on improving by having proper monitoring and testing of the policies. In case of any breaches, you should document the process, how these breaches should be communicated, should be identified, should be notified, and the conclusion each of these breaches. You should maintain the staff appraisal policy and also maintain policy and procedure with respect to engagement performance, engagement documentation, archival process. Each of these elements are important, and I would request my friends and colleagues to comply with each element of SQC thoroughly. Is there any question or anything we can discuss?
Sir, can you hear me?
Yes.
Sir, can you hear me?
Yes, I can hear.
Sir, due to the technical glitch, we haven't received any question yet.
Okay.
Thank you so much for the wonderful deliberation on SQC1. We have gained a lot through your deliberation, sir. Hope our members have also gained a lot through your detailed deliberation, sir. On behalf of AASB of ICI, I extend my heartiest thanks for sparing your valuable time and acceding to our request on a very shorter notice in this very hectic period, sir. Thank you so much, sir. Thank you so much, sir.
Thank you.
Thank you, sir. Thank you. So moving on towards the next technical session for today's VCM, that is relating to the SA 220, Quality Control for an Audit of the Financial Statements. We are having with us our eminent, learned, respected speaker, C. Hasmukh B. Dedia ji. So without wasting much more time, I request, sir, you are there? Sir, can you hear me? Sir, you are not audible. Sir, you are not audible. Sir, you are not audible.
Hello, am I audible now?
Yes, sir. Yes, sir. Now you are audible.
Yeah. Screen.
Sir, once again, welcome back, sir. So on behalf of WBSP of ICI, I welcome you for this VCM. Sir, may I request you to please kindly deliberate on SA 220, Quality Control for an Audit of Financial Statements. Over to you, sir.
Thank you, sir. Thank you, AASB, for inviting me to share some of my thoughts on SA 220. It is indeed my pleasure to be here amongst the chairperson Singhal Saab and vice chairperson of AASB Vishal Doshi and my co-speaker Sandeep ji. As it is, I hope my screen is visible, sir.
Yes.
Yeah. So since most of the items or most of the subject matter considered by my co-speaker earlier would overlap, I would try to the best of my ability to reduce or minimize the overlap and focus more on a practical aspects rather than going through the slides or the theory that is of 220 that is contained in my slides. The first question before coming to the slide I would deal with, which I think has already been dealt with even by the chairperson in his chairman also in his initial remark, that difference between SQC and 220. SQC, obviously everybody knows that is at firm level and it is applicable or mandatory to every firm which is doing assurance job, either audit or reviews or financial information certification. It could be one person firm, it could be 2 partners, 3 partners, or it could be as large firm as several branches and more than 10, 20 partners. SQC is applicable and mandatory to all. SA 220, which is quality control for an audit of financial statements, is also applicable to all. As we go along the slides, we will also highlight the differences. The scope of this standard is to describe the responsibilities of the auditor regarding QC procedures for an audit of financial statement, as also responsibilities of engagement quality control or reviewer, EQCR, where applicable because firms may decide within its SQC policy which of its assignments would be subjected to EQCR under SA 220. SA 220 is premised based on the fact that firm is subject to SQC 1 because otherwise SA 220 will not have a lot of things that we'll see that is all based on SQC 1, which which my co-speaker has already dealt with. The ethical requirements, code of ethics and entire code which was referred to be always kept in mind for all the assurance assignment, needless to add that. Objectives of the SA 220, the audit complies with the professional standards and regulatory and legal requirements, as also the auditor's report is issued is appropriate in the circumstances. SA 220 contains certain terms like engagement partner, EQCR, engagement team, inspection, network, etc. All these definitions have been dealt with in the earlier session. I will not go into that. I would only refer to the inspection as the way it is defined in relation to completed engagements. Procedure designed to provide evidence of compliance by the engagement teams with the firm's quality control policies and procedures. So all that needs to be mentioned here is that having policies, procedures laid down, documented, communicated within the organization from top to bottom is one part, one aspect. Getting an assurance or getting a reward that whatever policies, procedures have been documented are indeed so followed and followed adequately and effectively. For that, the entire process of the inspection is needed, and that's where the entire layer of the SQC is on this thing. The other definition that I would only touch upon in SA 220, it is defined listed entity, which is pretty much the same as we saw in the earlier session, what is defined in ISQC. It is referred in para 21 of the same standard, SA 220. I'll come to that when we come to the applicability of SA 220. The monitoring process is, of course, giving an impression that there could be one QC review, which is in a practical parlance called hot review. That is SA 220. That report is not audit report or audit deliverables themselves are not issued before the QC clears the work. QC says that all the procedures or all the contentious matters or all the documents, etc., are in place, and whatever has been brought to his notice has been resolved and sorted out satisfactorily. And thereafter, the report is issued that we loosely or in a practical parlance call hot review. Whereas monitoring also refers to cold review, that is a process comprising ongoing consideration and evaluation of firm's system of quality control, including a periodic inspection of selected completed engagements. This is what in a practical parlance we refer to for a convenience as a cold review, a review done by the QC team after the audit report is delivered. The firm's QC system should include policies and procedures addressing each of the following parameters. We'll be seeing each of them very briefly because a lot of this has already been at a firm level, has been dealt with in the earlier session. I'll try to avoid the duplication or the overlap. So leadership responsibilities for the quality within the firm, yes. Ethical requirements, acceptance and continuance of client relationship and specific engagements, assignment of engagement team, engagement performance and monitoring. We'll deal with that very briefly and very quickly. So engagement partners should emphasize the team on the following, that is compliance with professional standards. When we say professional standards, obviously it would mean auditing standards, which were mandatory earlier also, and now the fact that Companies Act also recognizes and gives a due importance to auditing standards in section 143, 9 and 10 of that act. Also, the code of ethics of the ICAI and entire code play the paramount importance for the team to know, and engagement partner has a duty to emphasize the same on the team. The issuance of appropriate audit report, SA 700 guides on that. We'll not go into that, but responsibility of engagement partner to drive the team onto the appropriate audit report, the final deliverable. Ability to raise questions without fear. This is so with the client. This is so within the team up to the engagement partner also. Even a smallest member of the audit team can raise a concern or a question or a treatment of some contentious issue the way it is given. This ability should, the standard requires that this thing is inculcated into the audit team to ensure the professional skepticism and independence of the entire audit process. Needless to add, quality is essential and it is indispensable for all the engagement processes. And now we are all at a professional level seeing that several quality reviews happening both at a ICAI level, peer review or QRB, etc. And then, of course, at NEFRA level also, the AQR audit quality reviews are happening. Ethical requirements, the firm's policies should emphasize the fundamental ethical principles as per ICAI's Code of Ethics. This has already been dealt with. In Code of Ethics, the main elements involved are integrity, objectivity, professional competence, due care, confidentiality, and of course, professional behavior, which are reinforced by the firm's leadership, education and training, monitoring, and process for dealing with non-compliance as per the laid down policy of the firm. The independence vis-a-vis clients is always been a very, very important subject for discussion. By itself, it can be a topic for a full session. But within SA 220, EP to form conclusion on compliance with independence requirements, identify and evaluate the relationship that creates present or potential threats to the independence, evaluate the information on identified breaches, if any, of the firm's independent policies, take appropriate action to eliminate such threats or reduce them to an acceptable level. Engagement partner to refer to the firm obviously for inability to resolve any such matter so that firm can decide on the further course of action within the policy framework of SQC of the firm. Now, many a times we say that take appropriate action to eliminate such threats or reduce them to an acceptable level. A practical example can be given here is that many a times CA firms employ or recruit somebody who is known to the client, somebody who is related to the client either as assistant or as an intern, articleship, etc. Now, obviously, putting such a person as representative of the firm on the audit of the same client by itself may involve some sort of a threat. And what can be done for that? Yes, this is always an issue discussed, and one will have to monitor that such a person is never assigned any engagement of the same client with which he is related or with which he is convinced. So that can be considered as one of the steps which is taken to reduce the identified threat to an acceptable level. There could be several other examples also. So then acceptance and continuance of client relationship and audit engagement, again 220 deals with it in a greater detail. It was dealt with in the earlier session also. The matters to be considered include mainly identity and business reputation of the owners, KMPs, related parties, and those charged with governance. Nowadays, a lot of information about the companies, including not listed companies, is available on the social media, and that search should be done appropriately by the firm before accepting any assignment of a new inquiring client. The nature of client's operations is, for example, a gambling company. For example, in the olden days, I remember a company which was manufacturing the writing instruments, the pen, and one of the product of that pen was that such that it included some portion of a gold as a raw material in making that pen. This I'm talking about the time when Gold Control Act and other regulations were there, and the stock of the gold had to be monitored by the company in accordance with that particular laws frame for under the Gold Control Act. And company had in past twice or thrice noticed to be not in compliance with this and was penalized by the regulators. Even if the business of the company is a legal, say manufacturing of a writing instrument, but because of this non-compliance with the regulation, one should consider twice before accepting such assignments, having regard to the nature of business as also business practices and models. Nowadays, we see a lot of such this thing in the media also, that otherwise are good companies, but they fail in meeting with their borrowing obligations or other obligations and funds, this thing, if all this is known or that history is known, the client or associates of the client, one would rather think twice before accepting such assignments. Information regarding attitude of the owners, KMPs and TCWGs towards the matter, such as aggressive interpretation of accounting standards. No, we deal it with this way only and not willing to look at the other viewpoint. The attitude of internal control, whatever we do, everything is right. And you have come as a new auditor, you have not seen our company full, you have not gone through our control force. If that kind of a mindset, not receptive mindset to newer thoughts, newer ideas, newer processes for suggestions for processes improvement, etc. If those are known, then also one can think of and decide whether to accept such assignments. The client is aggressively concerned about low fees. Low fees is one of the indications that independence of auditors is at a jeopardy or at a possibility of a jeopardy. So that could also remain a cause of concern before acceptance or continuance of an existing client. Indication of inappropriate limitations on the scope of work, like client has, say, 4 or 5 locations where the production, manufacturing, etc. happens. And in the beginning only, you had said that in a year you do only based on the time and based on the cost involvement, you visit only 1 or 2 and not others, or some such conditions are put at the beginning of the audit only. One would again like to think twice before accepting such thing. Whether actually you may visit all the locations or not is different thing. But freedom to have that should be there, and one shouldn't be putting such limitations on the scope of the auditors, and therefore that is also an important consideration. Reason for proposed appointment of the firm, that is the firm which is considering to accept, or continuation of the earlier firm. Now, of course, law also to some extent regulates this. The company law has a rotation, several other regulations also have a rotation policy. RBI has come out with a very, very stringent rotation policy of 3 years, etc. In light of all this framework, firm will have to decide its acceptance and continuation of audit engagement. And as I said, based on the social media or lot of other sources of information like earlier auditors, like bankers, etc., one would get such information, and based on such information, an informed decision will have to be taken for acceptance. Availability of necessary capabilities. Earlier, in the earlier slide, whatever we saw was from the client's perspective or prospective or existing clients. These points are based on the firm's own perspective. Whether firm is capable enough, having regard to the team size, having regard to the team competencies, having regard to the dealing with the complex matters, those were encountered in the audit, etc. Whether firm should think of continuing or accepting such assignment is something that needs to be deliberated, and after the decision is taken, it should be properly documented with all the discussion that has happened at the level of engagement partner, the seniors in the firm, and the final decision takers. The final decisions with the reason should be appropriately documented. Engagement partner has an obligation to take into consideration the competence and capabilities of the team before he allocates the team for any work, etc. Obviously, in a normal size audit of, say, one manufacturing entity or one lending entity or an NBFC or a bank, one would need below engagement partner. There could be a senior manager, maybe assistant manager, and then a team of qualified, semi-qualified, or interns, etc. So technical expertise, practical experience, and knowledge of relevant industries of the team, understanding of firms. The team should have proper understanding of the firm's QC policies, professional judgment, etc. The compensation and recruitment are a part of the firm's HR policies, which are dealt with as part of HR policies. Again, here is a very, very important obligation on the engagement partner, because once team is allocated, it is normally challenging to change a critical member of the team in course of completion of this thing, having regard to the timeliness and the regulatory requirement of completion of assignment, particularly of listed and public interest entities. And therefore, forming a team for an engagement is a very, very important task. And as they say, well begun is half done. This is beginning for the engagement partner, and therefore will have to be done with due consideration of all the aspects. Of course, the responsibility of engagement partner is to direct, supervise, and perform the engagement. In terms of direction, responsibility, obviously ethical requirements includes, will have to be informed to every team member. The firm also has this obligation. The engagement partner has this duty to direct the members of the audit team. Objectives of the work to be performed, maybe different areas are given to the different team members. There could be team audit is all about teamwork. Even if I always say this, even if you are a Sachin Tendulkar of auditing, you can't be doing it alone. You need 10 other people, or maybe enough number of other people to make a team and come out with a good results. The nature of entities, business, the management, the people to be connected, the areas to be visited, the risk areas, audit areas, all that is are also governed by the other auditing standards, and those will have to be kind of direction regarding those will have to be given by the engagement partner to the team members. The risks which are identified and auditor strategy or audit plan to mitigate those risks within the clients, all that should also be directed to the team members. Detailed approach on the performance of the engagement. As we know, several audit procedures, substantive, analytical, recomputation, doing it yourself and then comparing the results. Several other procedures are there, and what procedures have been discussed, whether to be done on an Excel sheet or any tool that firm is using for this, direction for that is to be given by the engagement partner with the help of the manager if he has one. The periodic supervision of the work done, the tracking of the progress of the audit engagement. It is never advisable that engagement partners enter the team when everything is completed by the team and kept ready for the review. No, that is not advisable, particularly for large and medium-sized organizations or listed or public interest entities. Therefore, frequent and periodic tracking of such progress is considered necessary. Considering the competence and capabilities of individuals in the team members is also can be done if the engagement partner involves himself in the process of finalization or in the process of verification and in the process of interim or midterm reviews. Addressing the significant matters arising during the audit engagement. Many a times clients also expect that at the last moment there should not be any surprises or shocks. So such issues which team has raised, if the involvement of the engagement partner is there, those can be escalated to a proper level within the client's place to avoid a last minute surprise or a shock. Identifying the matters for consultation. In course of audit, many a times we all know some matters arise which are subject to several interpretations. Client has a strong view on it. Audit team member has a reason to believe that other view or other matter or different way to treat a particular item, a particular transaction, a particular item of asset or liability is more proper, and such matters where engagement partner will have to give leadership this thing and guide the team. If he also feels that the matter is complex enough, then it will have to be raised for a consultation. We shall deal with that in the next slide. The review here refers to the review done by the engagement partner of his team's work. as we said, a regular review about firm's policy, procedures, etc., whether those have been followed in course of completion or in course of carrying on of the audit or assurance engagement. The engagement partner shall review the audit documentation as and when they are made. It could be as was mentioned, either on a physical paper if the firm is doing that way, so that proper retrieval, proper indexing, proper order, etc. is maintained, or if firm is using some tool or software, the manner in which they are built up in this thing, engagement partner would need to have a discussion with engagement team to be satisfied that work has been performed in accordance with the professional standards, which includes the audit program and other instructions given to the team, and also the legal and regulatory requirements applicable to the particular client whose audit is being carried on. The appropriate consultations, wherever necessary, have been taken either of the engagement partner, or if engagement partner himself feels that this matter needs to be escalated up within the firm, then the consultation process is being done. And engagement partner needs to ensure himself about whether sufficient and appropriate audit evidence have been obtained by the team in course of the work or not. I was referring to matters which are by nature lending themselves to different interpretations, different connotations. Sometimes clients have a very strong view on some matters. Sometimes the regulation requires it to be reported in some matters. Sometimes clients are argumentative and they want it to be put in such a in a manner not harming them in the report. Many such matters can be, out of practical experience, can be stated. One or two matters which come to the notice is that companies' acceptance of deposit rules defines deposits in a manner that any client's customers deposits, advances remaining with the clients for the more than 12 months, etc. Those are deemed as a public deposit. Whether and how to deal with that in the report or in the CARO, etc., can give rise to such questions. There could be many other matters which need actually a proper consultations. Nature and the SA 220 requires that in such matters proper consultation has been taken. Sufficient resources are available to enable the appropriate consultation to take place. The nature and scope of such consultations are appropriately documented. What issues have been raised to the engagement partner, or if the issue is raised by the engagement partner himself within the firm, escalated to a senior partner or to the QC, or if the team of QC is there, to the team of QC, whether the questions have been raised are raising the issues properly, both the pros and cons and the other views, etc., and obtaining a conclusion from the consultations are documented and implemented properly. The consultations in this case could be either internal or external. If either the firm is taking opinion of an external expert, or firm is asking client to take opinion of an external expert, then within the provisions of SA 500 audit evidence, the documents, the processes will have to be carried out and appropriate documentation will have to be done. Some of these are already discussed in course of the proceedings earlier, whether the requirements of having an EQCR applies to all the engagements, something which has been discussed. Here the simple answer is that firm's policies should establish a criteria for conducting this. Of course, listed entities, mandatory engagement QC review should be there. Other than listed entities, it could be public interest entities, it could be government entities, it could be such entities where there could be additional threat of you being exposed to, or the firm being reviewed by some other regulator. In all such cases, it is better to put it in a policy that firm should have an internal EQCR policy would apply in all those cases. This has been discussed frequently. I can avoid that. Such small practice units could suitably use the services of qualified external persons whom they trust and with whom they can be connected. Considering the stringent timelines of completion of audit of a listed and a public interest entities nowadays, coupled with the regulatory compliance, I am specifically referring to regulatory compliance and requirements of uploading the financial results or the financial statements within half an hour or 1 hour with the concerned stock exchange, etc. The time of taking the documents to internal QC, it becomes a very, very challenging, and this is actually a practical challenge faced by many. Accordingly, it is imperative for engagement partner to plan and complete the entire audit procedure, both interim as well as final, well in advance, so that there is sufficient time for the QC reviewer to conduct its review properly and satisfactorily. SA 220 also lays down the procedures by the EQCR to determine that an engagement quality control reviewer has been appointed in a cases wherever the firm's policy says it should be appointed. Discussion of significant matters by engagement partner with the QC partner, not only at the end of the audit, but periodically also as and when the consultative matters or complex matters or contentious matters arise. Those discussions are necessary and documentations of those discussions is also necessary. Needless to add that the audit report to be issued by the firm not before the QC of the firm is complete and delivered. EQCR shall perform an objective evaluation of the significant judgments and conclusions reached in formulating the audit report, and therefore evaluation would involve discussion of a significant matters with EP, as I said, not necessarily at the end of the audit, but during course of the audit also this can happen. Review of the financial statements and proposed auditor's report obviously will be reviewed by the QC to see whether it is in accordance with the firm's practice and whether it meets the legal requirements or the particular regulatory framework. Review of a selected audit documentation relating to significant judgments made by the engagement team and the conclusions that it reached in the audit. Evaluation to be done by QC of the conclusion reached in formulating the auditor's report, and consideration of whether the proposed auditor's report is appropriate in the given circumstances. There could be matters that not only the matters are complex or contentious such that there is a difference between engagement team and EP. Obviously, in those cases, EP would direct and lead the team. But there are differences of opinion on some matters between engagement partner and the QC partner, EQCR. In that case, both should follow the firm's policies and procedures. SA 220 very, very clearly mentions. But I have seen in my practical experience that many firms actually fail to have a policy statement in their either SQC or 220. It is clearly mentioned that in this situation, whether they arise or not, they are actually rare, but whenever they arise, or even if they don't arise, firm should have policy in place, properly documented as to how to address such matters, whether to be taken to the senior most partner or the CEO, or whether to be taken to the external person for satisfactory conclusion on the matters. Monitoring, as I mentioned, is actually, it can be correlated to what we do, what we issue a report on ICFR. Companies are expected to have internal control framework, internal control pertaining to financial reporting framework. The auditors are giving the report that company has that framework. Now, whether the framework or policies and procedures, whatever are there, whether they are actually operating and operating effectively or not, that is a question which is done by monitoring. A similar example can be used here. Firm is required to have a laid down policies and procedures, not only for QC, but also for the engagement, for the audit, for several other matters covered by the auditing standard and the auditing practices. Whether all that is laid down is actually operating and operating effectively can be done by monitoring, and monitoring is one of the important tasks of the QC partner or a QC team within the firm. So this is an ongoing activity, and this can be done for even the concluded assignments also. The purpose of monitoring compliance adherence to the professional standards and regulatory legal requirements, whether the QC system has been appropriately designed, effectively implemented, the report issued by the firm or the engagement partners, whether they are appropriate in the given circumstances. Here, the documentation is not about the audit, it is about the review, etc. The auditor shall document the issues identified with respect to compliance with relevant ethical requirements and how they were resolved. If there were some ethical requirements or there were some matters which were of the confusion, when those were documented, discussed with QC, and how they were resolved. Conclusion on a compliance with independent requirements. Many such requirements nowadays come because somebody's partner, some being a director in a company, independent director, many CAs are independent director in some companies. Obviously, you can't be doing any assignments of such entities, and therefore independence requirement will have to be seen very, very minutely and cautiously. Annual declaration form was referred to in the earlier session. Some firms are also following, in addition to the annual independence requirement or annual prohibition, where they make entities prohibited, that in this entities we will not take any assignment. Annual independent declaration to be given by all partners, all team members of the firm, plus some firms also have a practice of doing it quarterly based on the changes taking place for any matter which give rise to independence related questions. Conclusions reached regarding the acceptance and continuance of client relationship, the nature and scope of and conclusion resulting from the consultations process that was carried out in course of audit and concluded. The QC partner shall document the procedures required by the firm's policies, that the procedures required by the firm policies have been performed. EQC review has been completed before the auditor's report or on the same day as auditor report was finally released to the client, and that no unresolved matters that would cause him to believe that significant judgments made by the engagement team and the conclusion reached by them were not appropriate. Last is, as I mentioned, what we call hot review is after the engagement is done, after the report is already issued. Is a cold review, and all other are within the framework of 220, done prior to the date of report. Post completion reviews should also be done to ensure that whatever policy procedures of QC and engagement partners obligations, etc., are actually followed. Required for select audit engagements, as we discussed, firm's policy can decide which engagement would be subjected to hot review, and cold review can be conducted actually for all engagement, so that firm is always ready with for any regulatory reviews, peer review, etc. And firm can satisfy itself that all the policies, procedures that it has framed are actually followed. The hot review might not review all the documentation. It might confine itself to faster completion of the review, so as to be able to release the report, which is time bound, which is pressurized by the clients. Cold review normally covers the documentation, the audit procedures, whether they are as documented have been followed, and whether the issues those were raised were appropriate and were sorted out properly, so as to arrive at a conclusion. The evaluation of conclusion reached in forming the audit report in hot review is of the paramount importance. Evaluation of conclusion reached in case of a cold review, audit documentation maintained to ascertain quality and appropriateness in issuance of audit report are all covered by the cold review. Uh, that's all that I had to say. If any questions are there, sir, I shall be glad to take away. Deal with the questions from the. Over to you, Chairman, sir. Hello.
Sir, can you hear me?
Yeah.
Can you hear me, sir? Sir.
Yes.
Thank you so much, sir. Thank you so much, sir. Thank you so much for enlightening all of us on this SA 220. We are having certain queries, sir. If you allow, kindly permit me, I
Sure,
ask a question,
sir. Sure, sir. My pleasure.
Sir, first question is, what would be the responsibility of the CA audit staff below EP or managing partner, even after report of matters or information or documents about the circumstances affecting independence of the auditor vis-a-vis clients, which compromises QC of the formatting independent opinion?
So I believe the question is the obligation or responsibility below the engagement partner, that is the manager, senior manager, etc. What is the responsibility of them for not highlighting it in a timely manner or not dealing with it in a appropriate manner? That's the question.
Yes, sir.
Obviously, if that person is a qualified CA, this thing obviously is also responsible within the firm's practice of allocation of the duty and allocation of the responsibility, job specification, etc. Of course, there would be implications under the law also. If it, I mean, there have been cases where engagement partners have been saying that he relied on his qualified team, his team, which was competent enough to deal with such matters. In those cases, the questions to the team leads or senior managers by the regulations were also they were also interrogated in the cases. There have been experience, precedences of that. So they also have a responsibility in addition to the responsibility within the firm's framework of the policies and procedures.
Yes, sir. Yes, sir. So one member is asking for your expert opinion, how systematic quality control is possible. So can you throw light on this key systematic, how we can go for systematic quality control?
I think the question is more on the hot review rather than the cold review. On the cold review, there are not. I don't see the querist has a focus. Hot review, yes, I myself mentioned in my slide that it is a challenging. More so because the timelines, completion. Many a times we see that large listed companies, large banks, large NBFCs, large manufacturing entities, they have audit committee or a board on say X date. The completion etc. happens barely 2 or 3 days before that. Of all the matters, those are discussed in course of audit, and time for the internal QC is normally many a times often it is not more than 2 days or 3 days. QC, this is always, jokingly said to in many firms that QC's work is only midnight work. So those challenges of timely completion and seeing that, and therefore I was constantly, at the cost of repetition, I was harping that engagement partners should always be in touch with the QC partner that has been assigned to his particular engagement, and should not wait for everything to be completed at the end moment when things are given to the QC for timely and smooth completion of QC. Otherwise, it really becomes a challenge. Within that, second answer to that is hot review. Firm can evolve a practice of a confined QC to some very, very important matters like assumptions, whether they have been done, whether, say for example, many firms have this, wherever a majority of estimates or assumptions made by the clients in making up the financial statements, how have the audit team dealt with that? What are the audit procedures? subjected on that, what was the conclusion, what were the issues raised, what were the questions asked, how was the answers or the documented answers from the clients were obtained. If such limited matters are seen by the QC, and QC itself can evolve a checklist to be seen at the last moment of few items, whether this is done, that is done, this is done, that is done. Based on that, a release by the QC can be given the time challenges to the QC.
Yes, yes. Thank you, sir. Sir, whether reviewing partner is compulsory in all the cases?
Sorry?
In case of the good quality check, reviewing partner is compulsory in all the cases.
SA 220 says that all listed cases should be covered. Plus, firm's policy can determine which other entities also they would be covering by within the SA 220. But the other review, the cold review, firm should have a practice. It is good to have also, and ISQC mentioned that also. It's good to have that in all cases, barring some very small, very insignificant, no public interest entities. Otherwise, the cold review should be happening in most of the cases. I'm saying whether SQC or no SQC, whether auditing standard or no SQC. But as we all are saying, as our president also recently said, that audit is a very serious business, and those who are doing this business, they'll have to take it very, very seriously. From that point of view, it is advisable that cold review at least happens of all the assurance functions, all material assurance functions.
Yes, yes. Sir, is there any in case of audit, firm having more than 20 partners, can a partner may do the audit of the same client continuously for the 5 years?
Auditing standard itself says that rotation of the partner should happen every 7 years. Firm can have policy for such rotation less than 7 years. Auditing standard puts 7 years. 7 years is the maximum that a partner can do. Partner and the team will have to be rotated out. But large number of firms have now practice of changing the partners at 5 years. But auditing standard mentioned 7 years.
7 years. Fine, sir. So should we conduct annual risk assessment of our clients in order to be compliant with the relevant standards?
It is actually mandatory, sir. The new client acceptance plus every reappointment. Before acceptance or reappointment, many firms have evolved a checklist of few items which keep on occurring based on the past experience, whether they have occurred here and is there any threat on the independence. I mean, the entity was already our client, so we have already tested that we are independent vis-a-vis that. But whenever a reappointment happens within that period from last our conclusion period to now, has anything happened that our independence would be in jeopardy, or we need to at least check some of the matters, some of the developments which have taken place. Maybe they have some new director or independent director has joined there who has a connection with the firm. Maybe firm has done some work. Beyond auditing standard, if one goes by the code of ethics, the independence criteria enhances for the listed companies to so much that one will have to see vis-a-vis entire group, because within Companies Act, section 144 prevents up to a certain extent of task prohibited for the statutory audit. But code of ethics will have to be seen in a much broader aspect, whether you are independent not only vis-a-vis the client that is asking you to be, that is you are considering to be reappointed, but the entire group also, whether you are independent. That from that angle, if the client is listed.
Yes, yes. So last question is relating to this only. Should the quality control review be completed prior to the issuance of audit report, or should it be performed by another partner other than the engagement partner?
QC as a practice can be another partner, but who has never been a part of the engagement team. That is a condition. He can be another partner who himself is also an audit partner. So firms can do that. Instead of having a QC team, they have a cross QCs doing. But of course, there also they find challenge because that partner has time pressure of completion of his own assignment, and from that he has to take time out to make a QC complete. So I would say those firms who are doing a large audits, who are doing at least some public interest entities audit, they should evolve a separate QC within the firm or a QC team within the firm that is advisable. But other partner can technically be a QC.
Yes. Sir, thank you so much, sir, for sparing your valuable time, sir, on this SA 220. And on behalf of Auditing and Assurance Standard Board of Institute of Chartered Accountant, I extend my heartiest thanks for sparing your valuable time in this very, very hectic audit committee meeting periods and hectic season time. You have spared your valuable time and accede to our request on this to deliberate on SA 220. Thank you so much, sir. Thank you so much.
Thank you.
Thank you, sir. Thank you so much, sir.